Good afternoon, ladies and gentlemen. Thank you for joining us again. This is Dr. Olu Asekun here. It's a beautiful Wednesday. Please invite your family, friends, colleagues, and join us as we proceed with the immigration update under this new administration. As usual, today we will start with the update between last week and now. So, this administration, as we probably already know, they are not short of any news or update from time to time on immigration. So today we have a few updates that we want to talk about. So for this week, the first update we are going to be talking about is that American Immigration Lawyers Association notified us that USCIS will be increasing premium processing fee for certain applications effective March 1st, 2026. So it is not every application that is affected, but just a few. The applications that are affected, if you are asking for premium processing for R1, the premium processing fee has been increased from 1,685 to 1,780. I think that is just a difference of 1685 to 1780. I guess that's about $95, I think. It's not a whole lot, but at least it has increased. It's important to know because if you apply for premium processing and you submit the incorrect fee, the application will be rejected. So that is why we are providing this information. Another category that was affected is O visa. Premium processing for O visa increased from 2,805 to 2,965. I believe that's an increase of about $70. H-1B is not affected at all. The premium processing fee for H-1B remains the same. I-140, immigrant petition for alien worker, EB2 category, both national interest waiver and the non-national interest waiver. The premium processing fee increased from 2,805 to 2,965. I believe that's an increase of $70. I-539, that is application for change or extension of non-immigrant status. Premium processing for that also increased from 1,965 to $2,075. I believe that's an increase of about $80. Finally, employment authorization for both OPT and STEM OPT, regular OPT and STEM OPT, the filing fee for employment authorization increased from 1,685 to 1,780. I believe that's an increase of $95. So please take note of all these new fees because if you send in an application with an incorrect fee, the application will be rejected, and by the time you receive it back, you may have been out of status in some cases. So that's why it's important to keep this information, to keep you updated about this information. Okay, the next update we'll be talking about today is that the DHS, that is the Department of Homeland Security, they announced that effective March 17, 2026, they will be terminating TPS for Somalia I'm sure that this should not even be news because anyone watching the news since yesterday, it was all over the news because of what ICE is doing in Minnesota. And the president is really targeting people from Somalia. So they announced that they will be terminating TPS for people from Somalia effective March 17 of 2026. Another update that I know that will probably affect some of the people that watch this podcast, based on the question that we receive from time to time. I know that we have a lot of people on R1 who listen to us, who watch this program, who ask questions. So this one will affect religious workers. So as at today, the non-minister category is set to expire by 11:59 p.m. on January 29. January 29 this month. That's about probably 2 weeks' time. So the non-minister category is set to expire in 2 weeks' time. I don't know what to say. I hope that the Congress will look beyond politics and extend it. But as of today, it is set to expire by 11:59 p.m. on January 29. So by January 30th, unless it is extended, there will be no non-minister category for religious workers. So, and this, of course, will affect even people who have approved I-360 and all that, because without visa category, without being extended, immigration or the Department of State, they cannot issue green card or issue immigrant visa on that category for non-ministers. So I am hopeful that the Congress will see reason and they will extend it. I mean, this administration, they give the impression that they are really in favor of Christians, in favor of religious people. Hopefully, they will see reason and extend it. But as it is, it's going to expire in about 2 weeks' time. The next update we want to talk about is that on January 9, which was last Friday, USCIS announced that they have started reviewing all approved asylum and refugee application and all approved green cards based on asylum between January 21st, 2021 and February 20, 2025. So effectively, during the entire 4 years of President Biden, any green card that was approved, any asylum that was approved during those periods, DHS announced that they have started reviewing them. So they are reopening all the green card cases that were approved between January 21st, 2021 and February 20, 2025. All the asylums that were approved, they are reopening all of them, and they are reviewing them. That's the word they use, re-review, because it was previously reviewed before it was approved in the first place. So they are re-reviewing everything. And they are also, in the announcement, they mentioned that this process started from Minnesota, but they are expanding it to the entire country. And when they announced it on Friday, they indicated that as at that Friday, when it started, that they already detained, ICE already detained 2 people that they believe that shouldn't have been approved and were approved. They already detained 2 people as a result of this review. So that was the announcement on Friday. And the two people that they claim they detained, one is a Somali national and the other one is from Bernice. Bernice national. Where is Bernice? Yeah, Burmese. Oh, is that Burma? Oh, that's Burma. Sorry. Yeah, that's Burma. Yeah. So one is from Burma, one is from Somalia, according to the Department of Homeland Security. They started this re-review on Friday, and as at that Friday, they claim they have already arrested and detained two people based on this re-review. They also, uh, in that same announcement, they informed us that the re-review program is going to be known as the program is tagged Paris, Operation Paris. Paris means post-admission refugee re-verification and integrity strengthening. Post-admission refugee re-verification and integrity strengthening. Paris. That is the announcement they gave to us on Friday. That was last Friday, January 9. Now, the next update, before we go into questions, the Department of State also updated the list of nationals who will need visa bond. They updated the list of nationals who will need visa bond. And they also announced the implementation date. They also increased the number of airports that will be processing people who come in after they have made the visa bond. So the countries that are now included based on this update: Algeria, their own will be effective January 21st, 2026. Angola, effective January 21st, 2026. Antigua and Barbados, January 21st, 2026. Bangladesh, January 21st, 2026. Benin Republic, January 21st, 2026. Bhutan, which country is that? Bhuta. Bhutan, okay. January 1st, 2026. So that one is already effective. Botswana, okay, those must be part of the countries that were initially on the list. So the new ones are the ones with future date. The ones that were on the list before were the ones with the previous date. Well, it's between 5,000 and 15,000 depending on each category, and applicant has to be instructed by the consular officer to pay it. You can't just go ahead and pay the bond unless they ask you to, because I think the plan is they first need to determine that they are going to issue you a visa, and then we ask you to pay the bond. But if they are going to deny you visa in the first place, so there's no point paying the bond. So that's why they said no one should pay the bond until they have been instructed to do so. So, Botswana, January 1st, 2026. Burundi, January 21st, 2026. Cape Verde, January 21st, 2026. Central African Republic, January 1st, 2026. Cote d'Ivoire, January 21st, 2026. Cuba, January 21st, 2026. Djibouti, January 21st, 2026. Dominican Republic.
Dominica Island or Dominican Republic?
Well, I have.
Is it Dominica?
Yeah, it just says Dominica.
Is the island?
Okay, yeah. Dominica, January 21st, 2026. Fiji, I believe that's an island too. Fiji Island. Okay. January 21st, 2026. Gabon, January 21st, 2026. The Gambia, October 11, 2025. Guinea, January 1st, 2026. Guinea-Bissau, January 1st, 2026. Kyrgyzstan, I don't know how to pronounce it. Kyrgyzstan. 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 Number 20 on this list. Kyrgyzstan.
Yeah, Kyrgyzstan. Yeah.
Yeah, so Kyrgyzstan, January 21, 2026. Malawi, August 20, 2025. Of course, those are the ones that were on it originally. Mauritania, October 23rd, 2025. Namibia, January 1st, 2026. Nepal, January 21st, 2026. Nigeria, January 21st, 2026. Sao Tome and Principe, October 23rd, 2025. Senegal, January 21st, 2026. Tajikistan, January 21st, 2026. Tanzania, October 23rd, 2025. Togo, January 21st, 2026. Tonga, January 21st, 2026. Turkmenistan, January 1st, 2026. Tuvalu, January 21, 2026. Uganda, January 21, 2026. Vanuatu, which country is that? Vanuatu, I'm not even sure. It's Vanuatu. I don't think I've heard about it before. Vanuatu. January 21st, 2026. Venezuela. Oh, it's an island. Oh, okay.
In the South Pacific, Melanesia?
Oh, Asia.
Melanesia.
Oh, okay. I've never heard about the name before. Vanuatu. Okay. January 21st, 2026. Zambia. August 20, 2025. Zimbabwe. January 21st, 2026. In addition to this new update, because they have now increased from initial, I think they started with originally with 5 countries. So because they have now been increased to 38 countries, they have also increased the airport where these people can come in. So you cannot just come in at any airport. You have to come in from one of these, is it 9 or 10 airports? Boston Logan International Airport, John F. Kennedy International Airport, Washington Dulles International Airport, or is it Dulles?
Yeah.
That's Washington, D.C. International Airport. Newark Liberty International Airport, that's in New Jersey. Hartsfield Jackson Atlanta International Airport. Chicago O'Hare International Airport. Los Angeles International Airport. Toronto Pearson International Airport. And Montreal Pierre Elliott Trudeau International Airport. So those are the only airports that anyone on this list can come in from. Of course, DFW is not there. There's no airport there from Houston. I don't think there's not even any airport from Texas on the list. Yeah. So those are the only airports that people coming in from any of the listed countries can come in from. Now,
Just to understand it better, so the bond is paid at the embassy,
yes.
and they can only choose those airports to come in through. with
Yes,
evidence of the
yes,
payment.
yes. If you are coming from any of these countries, if you apply for visa, you go for interview, then the consular officers determine whether you need to pay bond or not. So if the officer determines you need to pay a bond, the officer will tell you the amount. The amount ranges from $5,000 to $15,000. After telling you the amount, now when you want to buy a ticket, you can only come into the United States from one of these airports. You cannot go through any other airport. So that's what that means.
So they would just send it back, pretty much.
Of course, I'm sure they are probably going to provide the information to the airlines. So even if you attempt to come in through a different airport, the airline will probably decline, because you know the way government operates. They'll probably put some some form of punishment hanging on the airline if they don't follow these things. So the airline will probably not even allow you to board if you are from any of these travel ban countries. Now, before we go into the questions for today, I have a few information that I got from one of my sources. Now, information from one of my sources indicate that officers at USCIS offices nationwide are seeing a reduction in assigned interview days. And my source predict that this will cause a slowdown in processing. Now, because of this, some officers are now being reassigned from interviewing to NTA duty. NTA is notice to appear. So my source informed me that an NTA will be issued 45 days after a denial or abandonment or a withdrawal, unless the case is either refiled or a motion to reopen is filed, or in the case of citizenship application, N336 review application is filed. So if none of this happen in 45 days, they are going to issue notice to appear and place the applicant in removal proceedings. Additionally, my source informed me that that interview cancellation are only happening right now at USCIS office for individuals from countries impacted by the ban, by the travel ban. In other words, they are only canceling interview for people from any of the countries listed on the travel ban. So if you are not from the travel ban countries, the interview continues. They continue to conduct interview. But of course, because of all this cancellation, and of course, you know that majority of applicants are probably from these travel ban countries. So if you take all of them out, so a lot of officers right now, they are redundant. They don't have any job doing. So because of that, they reassign them to notice to appear. So now there probably will be increase in the number of notice to appear that people are going to be receiving. People who ordinarily would not have received notice to appear, they probably will start receiving it now, because many of these officers are now reassigned to notice to appear duties since they are not able to do a lot of interview as they used to do. So I wanted to put that out there so that if your case is denied, you need to quickly, as much as possible, you need to either file a motion to reopen or file an appeal or refile your case. You just need to take some steps, because if you don't take any step, you are probably going to be getting a notice to appear. Okay. Well, I just have an information passed to me now.
10 minutes ago.
I have an information that was just passed to me now. USCIS 10 minutes ago just released an update regarding religious workers. So they are saying that religious workers will no longer need to reside and be physically present outside the United States for 1 year at the end of their statutory 5-year maximum admission period of stay to be eligible for readmission in R1 status.
So they can just keep on renewing it?
That's what I'm trying to understand. This improvement will promote stability and minimize disruption to the essential services provided by non-immigrant religious workers. where are the details? So are they go because the 5 years is statutory. So USCI does not have the authority to unilaterally increase it except Congress do something about it.
It's here, so I mean we can review it and then
Well, maybe I'll talk more about it next week because, like I said, they just released it about 10 minutes ago. I've not had the time to go over it. But I can tell you that even in this office, we have always prevented people in R1 from going out of the country in any case. I mean, we used to change their status from R1 at the end of the 5 years. We just change their status to another non-immigrant status just to keep them legal. And like I said, by the time I read the entire release, I'll be able to know the details, how this is going to work. Because for now, I know that the 5 year is statutory. It is the Congress that passed that into law, that religious workers cannot stay on R1 status for more than 5 years. That is the maximum. So after the 5 years, they will have to exit R status and get into another status or leave the country for at least 1 year before they can be readmitted back into R1. So with this announcement, what is not clear is that if somebody has spent the 5 years, now will they be allowed to continue to extend the R1? I don't have an answer right now.
so what it says is that they will still have to depart the United States, but they are removing the minimum amount of time so they could depart the US and come right back in.
Okay, like I said, I will, and I'm sure that American Immigration Lawyers Association is also going to evaluate. So I will not want to talk too much about it today because I don't want to give information that will turn out to be inaccurate. I do know that a lot of people rely on the information we provide on this platform, and I don't want to abuse it. I don't want to say anything that I'm not sure of. So all I can say, for example, last week on air while I was here, something pop up on my phone says ICE agent shot. I didn't read the entire thing, so I announced it on the program. Eventually, after we finished the program, I now realized that it was actually ICE officer that shot somebody. But as it pop up on the phone, it just says ICE officer shot. Of course, I didn't read the entire thing. So that is why half information is very, very dangerous. So I'm not going to do the same thing again. I learned from that one last week. So I'm going to address it next week. So if you are in that category, you have questions about it, wait till next week after I've had time to review it, and then we can discuss it and ask questions. So for now, that is going to be the update we are going to be talking about. So if you have questions, and I can see that it seems a lot of questions have been coming in, so let's start rolling. Okay, very first one. Happy New Year to you, Dr. Olu and your team. Happy New Year. God bless you and protect you. Amen. Please, sir, can a green card holder file for his or her manager couple, assuming the husband is the green card? What do you mean by manager couple? Okay. Is there a part B? Okay. Assuming the husband is the green card holder and the marriage wife is already in the US on a B1, B2 visa. I'm not sure I understand the... Roll it back a bit. Let me read it from the beginning. Okay. Happy New... No, where did the question start from? Okay. Can a green card holder file for his or her manager couple? I'm not sure I understand it. Is this a business owner who is trying to find out if the business can petition for the manager? Because how can a green card holder cannot even file for anybody outside of his own immediate family? Not even the entire immediate family, because a green card holder cannot petition for parents, for example. They cannot petition for siblings, for example. A green card holder can only petition for his wife or husband, or children, minor children under 21, or unmarried children over 21. Those are the only three categories of people that a green card holder can petition for. However, since this person is talking about manager, so I'm assuming that he's talking about business. So can a business owned by a green card holder petition for somebody? Yes, the answer to that is yes, if they meet the eligibility requirement. So if you are the owner of the business and you are a green card holder, if your question is whether the business can petition, yes, a business is registered and has its own standing in law. So if the business meets the requirement and the beneficiary too meets the requirement, yes, you can petition. For example, let me give an example. Let's say a green card holder owns maybe a nursing agency. Can the business petition for a registered nurse? Oh yes, the business can petition for a registered nurse. Yes, the business can petition, but the green card owner personally petitioning for somebody else, that one is not available. Even a US citizen cannot even do that, talk less of a green card holder. But if it is the business, the answer is yes. So let's go to the next question. Hello, doctor. Compliment of the season, sir. Compliment of the season. Thank you, too. Sir, my asylum application relates to submitting a death certificate of my younger brother who died in 1975. All I have as proof of death is a death certificate from a private hospital that confirms his passing at that time, 1975. No other form of death certificate was obtained by my parents aside from the one from the private hospital. Two things now, sir. One, the hospital is no longer in existence. Two, is this death certificate from the aforementioned private hospital tenable to support my case? Sir, I need your strong advice on this as usual. Is it the same person? Okay. God bless you and your team. What can I do or submit it? Okay, that's a very good question. One, you can submit the death certificate from the private hospital. However, you are going to face some challenges, and I will tell you how to take care of those challenges. Number one, the first challenge is authentication, what is called authentication. Since you said the hospital is no longer in existence, it's going to be difficult to authenticate the death certificate, which we mean that immigration will give extremely little or no weight at all to that death certificate. So now, how do you fix that? The way you can fix it is that you take that death certificate from the private hospital, you take it to the National Population Commission in your state. So once you take it to the National Population Commission, you also attach a sworn affidavit along with it. It can be done by you, it can be done by any of your parents or any of your siblings or somebody who has a first-hand knowledge of the event that led to death or first-hand knowledge of the fact that that person is dead. So you take it to the National Population Commission and then you apply for what is called attestation of death. So the National Population Commission in Nigeria will give you attestation of death. But for asylum purpose, especially if you are in court, even when you get the document from the National Population Commission, it will still require attestation. So, not attestation. What did I say originally? No. Authentication. Yeah, sorry. It will still require authentication if you are in court. But if you are still with USCIS, the death certificate itself and the attestation of death from National Population Commission will be sufficient. But if you are already in court in removal proceedings, you will need the death certificate from the private hospital, attestation of death from the National Population Commission, and then you need to have the attestation of death authenticated. So those are the things, that is the way to resolve that. Next question, please. Happy New Year, sir. My Happy New Year to you too. My son EAD has a bad error on it, and I sent a message to USCIS, and I was told to send it back, which I did since June 2024, and now the EAD has expired, and I sent renewal since December 2024. I only got a receipt notice and 540 days extension letter. The processing period window says January 3rd, 2026, and now it has changed to February. So what can I do, because it's affecting my son's college application? Well, I will tell you to submit a service request. Oh, there's more. Okay. Okay, due to the age difference. Some college gave him admission while some say they couldn't verify his age. I'm on VAWA and it's under my application. Should I do expedite request? Well, I'm not even sure if expedited request is applicable in this case, but go ahead and submit a service request. Submit a service request and is somebody still able to reach USCIS on the phone nowadays? I'm not sure. Well, you can give it a call, but the first thing you do is to submit a service request and then try to call USCIS. I'm not sure if a non-attorney will be able to reach anyone, but I've seen people say that they call USCIS, so it is possible. So I'll tell you to give it a call. But if those things don't work, then I will tell you to try congressional intervention.
And the son would have to call. It can't be the parent.
Yes. If you are going to call them, yes, it will have to be your son. It cannot be you. So, because they will verify identity before they talk to you. So if you try those two things and it doesn't work, then try congressional intervention. Look for the congressman representing your district, preferably a Republican, and then seek assistance. Because I said preferably Republicans because I know for a fact that USCIS is not responding to any form of assistance request by Democrats. I don't need to say more than that. You all know what is going on in the country. And our president has not hide his intention to be the retribution. How does he normally say, I'm your retribution? So he has not, that is not a secret. So next question, please. God bless you and team. Sir, I filed I-485 for self with wife and 2 kids plus I-765 for self and wife using G1450 credit card form. Payment were declined and USCIS affirmed on phone that they declined the card. Package rejection as seen on their website. Without waiting for the rejected package, I refiled a new package and completed biometrics. Only my wife's old package was returned, but payments were unexpectedly deducted for the other old filings. I disputed this with my bank and called USCIS. Service request was open and I'm awaiting a Tier 2 call. Now, new receipt numbers have been issued for me and my kids and biometrics scheduled for January 30. What should we do, sir? I intend the consultation, but you don't have any open slot before January 30th. What?
This question had already been asked last week.
Yeah, I thought about it, that this is a question that I thought I've seen before. But the truth of the matter is that I think he asked it differently. Last week, he didn't mention, he indicated that the first one was not cashed. But what he is saying now is that it's like they cashed the payment twice. It may be that the one that was rejected was the one with the issue of the credit card payment. Unfortunately, where USCIS is not the one that commit the error or make the mistake, they usually don't issue a refund. Even where they made mistake, they will send you a letter telling you that they will refund it, but eventually they may not. Probably, well, I won't blame you for being proactive, resending it back since you already got a confirmation that it was rejected. Most of the time, these problems are caused by the credit card companies because we have one now where I think, please remind me after the postcard to even discuss it, where I understand that one of our packages were rejected and we received it after the deadline. Meanwhile, I don't know what happened with the card companies, why it was rejected. I still don't know, but the point I'm making is that a lot of these credit card companies and even banks, they make errors in an attempt to protect people from maybe identity theft, from because especially towards December, November, December, there was hike in the number of fraudulent charges on credit cards. So a lot of credit card companies, they were taking proactive steps to not approve credit card transactions. And in the process, legitimate transactions were declined for verification instead of. So it may be that maybe they charge the first one. It may be that your wife's application that was charged first, and then maybe the bank reach out to you, and maybe you now confirm to the bank that it was legitimate charges, and then maybe the bank now decided to let the other charges go through. So most of the bank, it is not USCIS, it is actually the bank. So where this error is not from USCIS, I don't see them refunding your money. However, since you have already disputed the charge, I believe that the credit card companies will probably refund your money. But I don't know. It depends on individual companies. But what can you do about this? There is really not a lot of options. I hope and pray that they will call you, the second tier officer will call you as they promise, but it is unlikely they may not call you. So it is really, really a very tight situation. But since you have disputed the charge, I think you should be okay. For as long as the first one has gone through, you have the receipt notice, and you have also completed your biometrics, I don't think you have any reason to be concerned. But it's a good thing that you call them. So wait for the two-tier officer and see what the officer will say. Hopefully they will call you. That's the only thing I can say for now. Next question. Good morning, sir. Do F1 to EB3 sponsorship still exist for Nigerians in partial ban? Will USCIS still approve I-140 for Nigerians applying since the proclamation? Well, apparently, whoever sent this question has not been listening to our podcast because what we know is that USCIS will still accept the applications. They will still accept the applications. They will still process the application, but they will not adjudicate it at this time because the DHS, the Department of Homeland Security, have instructed them to place a hold on all these decisions on pending application from travel countries. They should not issue any decisions right now. They should not approve and they should not deny. They should just hold on. And if you listen to the update this morning, that is one of the reasons why I said that my source notified me that a lot of these officers, they don't have a lot of work right now because interviews they were supposed to be conducting, they have been suspended or cancelled. Review that they are supposed to be doing, they are not able to do it because they have been given instruction to hold on all these things. And I did remember when we mentioned it last week, is it last week or 2 weeks ago, that the government, USA, the DHS gave them, no, I think the government gave USCIS 90 days to come up with a plan on how to reevaluate all these applications from these travel countries. So if you submit your application, will they accept it? Yes. Will they process it? Yes. Will they approve or deny it? Not at this time. They are holding on to that right now, but they continue to accept applications right now. Next question, please. Good day to you and your team. As a green card holder through marriage, is it safe to travel outside the country? I'm a dual national. Thank you. Of course, for as long as your marriage does not have any issue and you don't have criminal record, yes, if you have a green card, you can travel. The travel ban does not affect people who already have their green card. You can use it to travel in and out for as long as you don't have criminal record. However, because you got your green card through marriage, I will suggest that you put your house in order before you travel. Make sure you are not in any kind of dispute with your wife. Make sure that you are aware of each other's movement. Why is this important? We are talking based on experience. I've seen a situation where somebody traveled with a green card, and then upon return, the CBP officer decided to pull the green card, and they realized that he got the green card through marriage. And then they called the spouse to ask the spouse, oh, where is your husband? And of course, the spouse, who unfortunately did not even know that the man traveled, told them that, oh, he's at work. Somebody who was just coming into the country. What does that tell you? That clearly shows right there that that marriage is not a legitimate marriage. That is a fraudulent marriage. How will you be in a marriage, how will you be in a legitimate marital relationship and you will travel out of the country and your spouse that you are supposedly living with will not be aware that you travel? I mean, it's not even a day's journey. We are talking of international travel. So that speaks volume. So if you got your green card through marriage, can you travel? Yes, but put your house in order and also ensure that there is no criminal record at all. Next question, please.
I have a question on Facebook.
Oh, okay. Can a lawful permanent resident from a partially banned country like Nigeria apply for his citizenship? Oh yes. You can apply. I just mentioned that right now. USCIS continue to accept applications. They continue to process it. Once you file it, they will send you receipt notice. They will send you notice of biometrics to go for fingerprinting. They will continue to process it. The only thing they cannot do right now until the suspension order is lifted is that they cannot approve or deny it. They cannot take a decision. But you don't want to wait until they start taking decision before you apply, because whenever they start taking decision, they will still take it on the basis of first come, first serve. So you can apply now, yes. But will it be approved right now? No, it will be delayed. But go ahead and submit your application and then go for your fingerprint. Let your application be there. Once they have been given 90 days to come up with a policy on how to deal with these all re-review cases, once they start, they will go back to the queue and your application will be right there. That is not when you want to start. So can you start now? Yes. Next question. Can a family-based I-485 applicant be considered out of status and detained by ICE for deportation when they have no criminal record? You see, this is not a yes or no question. Immigration is not a one-cap-fits-all. It's not a one-cap-fits-all. There are so many complicated stages with immigration. Somebody without any criminal record can still be detained. If you have been listening to our podcast, when the administration announced the 5 categories of people that they consider priority originally, because I'm not even sure they are keeping that right now, but originally, when they gave us the category of 5 people that they consider priority. The first set of people who already have a removal order. The second set of people who entered the United States without a visa in the last 2 years. We're now going to 3 years because at that time it was the beginning of Trump administration, and Trump administration has been there now for 1 year. So those who entered the United States without a visa in the last 3 years. Those who have removal order. 3, those who have criminal record. Those who have criminal record. 4, those who are encountered, and this is the category that may be affected here, and that is one of the reasons why I said immigration is not a one-cap-fits-all. Those who are encountered. The way I explained that at the time, which I'm going to do again now, is that let's say ICE is looking for Olu Asekun. They come to our office here in Arlington. At the reception, they met 3 people. The first thing they are going to do is to ask all those 3 people to identify themselves. If any of them does not have legal status, that person will be picked up by ICE. Even though that person is not the target, they were not looking for that person, but they encountered the person. They are not going to let the person go. So even if you have a family-based petition that is pending, if at that moment they encounter you at the reception, from the example that I gave, if you don't have anything that they can verify that shows legal status, you will be picked up. Unfortunately, is it right? I don't know, but it is what it is. So we are just providing you with the information. So I've seen a lot of people who get involved with ICE one way or the other. A lot of other things can happen, despite the fact that you have a pending case. Another example is somebody who is arrested for any crime, even though this person has not been convicted. The moment you are arrested and you are detained by the police, many of the cities and counties in the United States today, maybe with the exception of very few, many of them today, they work with ICE because this administration was offering money. I remember the city of Dallas debated it last year, whether to accept ICE money or not. They were offering them millions of dollars for them to cooperate with ICE. So many of these cities and counties, they already have this agreement with ICE. Once you are detained and you are not a citizen and you don't have a green card, they are going to place ICE hold on you. So even if you have a pending case, they will still place ICE hold on you. So you can still be arrested, you can still be taken to detention. Now you will now have to be applying for a bond. So, as I said, somebody with a pending family-based petition, can the person be detained? It depends on the number of factors. It is a possibility. I cannot tell you outrightly, no, you cannot be detained. No, I cannot say that, because in some cases, depending on the specific fact of each case, you can be detained even though you have a pending case. Next question, please. Good morning. Have you heard of any approval from either the full or partial ban countries? Thank you, sir. Have a nice day. When did the ban country start? I think it was January. That was last week. Was it last week? I'm trying to see if we have received any approvals since January from any travel banned countries. Okay, yeah. Not from the banned countries. We still receive approval from time to time, but not from the banned countries. And I was also hoping to see the court. I did, when was that individual hearing? There was one yesterday, and I think there was one last week as well.
There was one individual hearing last week.
Yeah. So we have a couple of individual hearings that I did. So we are waiting to see if the judge will actually issue a decision, because these were individual hearings based on uh, client from travel ban countries. So I will update you as we go. But as of today, no, since they announced the that they should suspend processing of the application, we have not. But since I've been to court, I've argued a few cases, so we are going to wait and see if they will issue a decision. Yesterday would have been a perfect example. For some reason, the case didn't go on because of some detained cases. So the judge was not able to get to us, so they had to reschedule it. But of course, from time to time, I will continue to update us as we go. Next question. Good day, Dr. Asekun. If a derivative, a son, moves to another state for work, does he have to submit change of address? I-485 is pending. Parents is still in the same address. Well, there are some issues here. If you don't submit a change of address, if they schedule him for interview or for biometrics, he will have to travel home. If you submit a change of address to his school, if they have to schedule him, they will consider that new address and schedule him for interview over there. So it's entirely optional to you. As far as the law is concerned, since your own address is considered the primary address, doing a change of address is not mandatory because your address is the primary address. But for convenience, it is entirely optional to you. If you look at the cost of bringing him back, especially if your case requires fingerprinting and the fingerprinting has not been done, it may be required to come home multiple times. But if I'm in your shoes, sometimes it is better to keep everything in one spot than to start separating it, because the moment you submit a change of address for him alone, there is tendency that immigration can mix up your file and that can disrupt certain things. So if I were you, since your address is the permanent address, I will leave it at that. Next question. Hello, does the ban to 75 countries affect individuals with pending application in the US? Right now, yes, because all applications have been put on hold. It doesn't mean they are going to be denied. It simply means that they ask them not to work on it right now, to put a hold on it right now. So it's going to cause some delay. Yes, it will cause some delay. Good afternoon, sir. I'm excited to be here. Oh, thank you. Okay, good afternoon, doctor. Thank you for all you do and your team. Thank you. Kindly reply my mail. Thank you in anticipation. Can you check who this person is? And yeah, please note it and remind me after the podcast. Okay, next one. Hello, doc. Hello. Okay. I'm the guy that told about my meeting with Fox News to tell my story. I'm still waiting for an update. Any update on that one? Anyway, we can't even give the update. If there's an update, we can't give it live like this. So, can you please note those two people?
Yeah, I know one of them.
You want to write it down so that I don't forget, please.
I've taken screenshots. Because I don't know who the other one is, but
Said after our
Do that.
discussion, I'm yet to hear from you on the next step.
Yes. Okay, go to the next question. God bless you and your team member, for all your effort and the services to humanity. Thank you. God bless you too. Sir, with the ban and pause on processing of benefit, what would you advise an asylee whose asylum was granted by an immigration judge in October 2021? Can I move forward with getting ready to apply for citizenship? Ekushesa. You see, we are in a very unprecedented time. Unprecedented because this administration is doing a lot of things that we have not seen before. And because we have not seen it before, it is difficult to determine what is likely going to happen based on experience, because this is not something we have experienced before. To the best of my knowledge, an asylum application that was granted by an immigration judge will be extremely, if not impossible, to revoke. That is my opinion. Immigration court is not the same as USCIS. USCIS is under the Department of Homeland Security. So they are the ones that are responsible for conducting affirmative asylum interviews. This review, in my opinion, is probably going to be limited to those interviews conducted by USCIS officers. The ones that were granted by an asylum judge, the reason it will be difficult to revoke is that once a judge gives a verdict, the judge is going to ask both the government lawyer and the respondent lawyer, do you accept my decision as final, or do you want to reserve an appeal? So if both of them told the court that they accept the decision as final, then they cannot appeal after 30 days. They cannot. Appeal period is within 30 days. Whenever a judge gives a ruling, the government can appeal it, but they have to do it within 30 days. The respondent can appeal it, they have to do it within 30 days. So any application that was granted by a judge, they can't revisit it in 1 year's time, even in 2 months' time, because the appeal period has elapsed. So that is why I am confident that I don't think they can revisit any case that was granted by an immigration judge. Now, this limitation does not apply to any application that was granted by a USCIS officer. That one, there is no deadline. They can reopen the case at any time. They can reopen it 2 years after. They can reopen it 3 years after. There is no appeal period. There is no deadline. So those are the ones that I believe they can revisit. They cannot revisit anyone that was granted by an immigration judge. In addition, even those ones that they are going to revisit, if they revisit it and then they decide to reopen the case and deny it, you know what they are going to do after? They are going to send it back to an immigration judge. They are going to put the respondent, the applicant, into removal proceedings. So an applicant who has already gone through that process and the DHL did not appeal, they are not going to have the legal basis to be able to revisit that. But they can continue to revisit those that were granted by an asylum officer. So coming back to your question, since your application was granted by an immigration judge, if I were in your shoes, I will go ahead and apply for citizenship. Of course, they are not going to take any decision right now because of the hold, but submit it and wait. Whenever they open it, then you'll be able to proceed with your citizenship application. And besides, again, all these things, a lot of people don't understand the way the law works. Even if they reopen your case, I'm talking of those who have already gotten their green card. Even if they reopen your case and they found out that you shouldn't have been granted the asylum, Because you are now a permanent resident, you will be open to some reliefs. For example, you may be eligible to apply for what we call 237A1H waiver. You may be eligible to apply for cancellation of removal for legal permanent resident. You may be eligible for a waiver. Every case is different. There are a lot of things that somebody with a permanent resident card can do, and those who have not been granted permanent resident cannot do. So, if your asylum was granted, but your permanent resident has not been approved, your options are still limited. But if your green card has already been approved, you have a lot of options, even if they reopen and revoke it. Next question, please. Good day, sir. God bless you and your team in Jesus' name. Amen. Sir, you need to rest too. Thank you. Yeah, this person actually noticed the stress that it's been a little stressful. But what can we do? Thank you for the observation. Thank you. I appreciate it. Next question. Thank you, sir, for all you do. I got my green card in 2021, and my teenage son got his own in 2022. I am due for citizenship in February 2026. Can I go ahead and include him in the application? Well, you didn't indicate how old he is, but irrespective of his age, anyone applying for citizenship must still answer all the questions correctly. So you have to list all your children. So you still have to list him anyway. But for the purpose of citizenship, if he's under 18, you don't need to file a separate application for him. You just need to file only yours. So whenever yours is approved, on the day that your citizenship is approved, if your child is still under 18, he will become automatic citizen on that day. So you don't need to file a separate application for him. But if he's over 18, then he will need to apply for citizenship on his own.
Whenever he qualifies.
Yeah, whenever he meets the requirement. Yeah, but if you become a citizen before he turns 18, it will not matter when he got his green card. Even if he got his green card 6 months before that time, he will still be automatic citizen. But if he has to apply on his own, then he will have to also wait and meet the physical presence requirement. Next question. If your green card case is denied because of late marriage, can you file I-130 with the overstayed visa? So is this a K1 issue? This question is not complete.
Late marriage?
Yeah, because the only situation where I can think of a late marriage is if somebody enter with a fiancé visa. Fiancé visa is valid for 90 days, and you have to get married within 90 days. So if you didn't get married within 90 days, that is considered out of status. So the question is, that is the way I interpret the question, even though it's not very clear, but that is the way I interpret the question. What I would suggest is, if you didn't get married within the 90 days that you are supposed to, when you apply, when you file the I-130, you have to attach a detailed explanation, a sworn affidavit explaining in great details why you didn't get married within the 90 days, because the 90 days is statutory. So, and if you didn't get married in 90 days, it simply means that you are out of status. It doesn't mean that you cannot still get married, but it means that you are out of status. And of course, any consequence of anybody being out of status, you will also suffer the consequence. But you can still get married, you can still submit your application, but you have to include a very detailed explanation as to why you are unable to do it within the 90-day period. Next question, please. Good morning, doctor. I got my green card through immigration court. Can this Trump stuff affect me? And also, can I go ahead and apply for travel document? Thank you. Yeah, I think I already addressed that extensively. since you got it from the court, it is unlikely going to affect you. Can you apply for travel document? Yes, go ahead. But again, because all relief applications have been placed on hold, your application for travel document may be delayed. But you can go ahead and apply so that whenever they start, that's not when you are going to just start applying. Next question, please.
What's this high? Let me see.
Hi, is there a question?
I don't think so. I think he was just grading you. No, there's nothing. Okay, so the next one is this one. You already addressed that one. This one right here.
Okay. Good afternoon, sir. I got my parole by VAWA. Am I safe to travel with it this time around? Ordinarily, according to the president himself, according to the proclamation that was issued, people who are affected are the people who are going to the embassy to apply for visa, not people who are in the United States originally, not people who have already been approved either as a permanent resident or as a citizen. Now, in the proclamation, they didn't mention anything about anybody traveling with travel document. Because of that, and because of the haphazard way that this administration is enforcing the law, if I were in your shoes, I will not travel on this time, at this time, until this thing is very clear. Because, as I said, despite the fact that every single day we try to catch up with the policies, they keep coming up with new thing every day. I mean, you can see the sample. While this podcast was going on, they just released something. Now, USA just released something. So every day, this thing keeps changing. This is since I started practicing immigration law several decades ago, this is the first time that there is the level of uncertainty is very, very high. You are working with something, and then suddenly, by the time you look back, they have changed they have moved the goalpost in the middle of a game. So nothing is predictable. Okay, let's look at another example. Look at the travel ban. When they released the travel ban, in the president's own proclamation, he specifically stated that everyone who are currently present in the United States is not affected. In fact, they specifically stated nothing in this proclamation affects anyone from any of these travel ban countries who are physically present in the United States. That was what they announced, and that was what we believed. Then came end of December. Then came January 1st. Then they announced another one that, people from travel ban countries who are now in the US, all their applications must be placed on hold. I mean, that is the height of inconsistency. So considering the lack of stability with this administration right now, and the kind of the way they are so obsessed with immigration, I don't even know what the president is thinking. He's so obsessed with immigration. It's like that is the number one thing that they are talking about every minute. I think he's enjoying the way ICE is disrupting the entire countries, even though now they started arresting American citizens. I mean, I saw in the news yesterday 2 American citizens who were arrested at, was it Home Depot or something, in one store. I mean, come on. These are things that I would have believed that can never happen. Why would they want to arrest? I understand in one of the social media posts, I didn't verify, I don't know whether it is true or not, but it says that they were arrested because they were recording. Since when has it become a crime for an American citizen to use his phone to record a scene? That's not a crime. So if that is truly the reason they were arrested, I believe those people should sue ICE, because That is completely uncalled for. So if they can do that to American citizens, so who am I to tell you that you are not even a citizen to guarantee you that there will be no problem upon your return? You have to look at the totality of the situation, and we have to also apply some wisdom. While I love fighting for people, it is also smart to avoid some fight. Any fight that is avoidable, let's just avoid it. So back to your question, will I advise you to travel? It's entirely your decision, but I will not at this time. Next question. God bless and keep you, Prof. may God all says may God all says keep you, your team and family. Amen. Please, is there any need to expedite OPT during the USCIS pause since we are from partial ban country? I don't think there's any need, because what's the purpose of paying for it when they already said they should not adjudicate it? I don't see any need. Again, this is part of the inconsistency that we are talking about. I mean, just yesterday, these people announced increase in fee for OPT. Now, for increase in fee for premium processing for OPT. So the question is, with the travel ban now, does it make sense for somebody to apply? Well, to be honest, I don't know the answer to this question. If you have a lot of finances to spare, you can test the waters. Like I said, I don't have precedent that I can use to tell you that based on this will be the outcome. The policy says they should put everything on hold. Now they increase the premium processing fee. Will they process it? Yes. Will they approve it? I don't think so. To be honest, it's your decision, but if I'm in your shoes, I will not even bother to waste my money. Because since they are not going to process it, what's the point of applying for premium processing? Okay, next question, please. Hello, sir. I am Nigerian living in the UK, and my EB1A application has been under administrative processing for 10 months now. Our passport and all our documents are at the embassy on request.
No, I'm coming. There's a part 2. This one.
Okay. I have another EB-NIW application, and I got an interview letter for an interview in February. I am stuck as to what to do. Kindly advise. Well, what I will tell you is that there is no consular officer, none, that will defy the proclamation, the travel ban. No consular officer will do that. So what I will advise you, contact the embassy and tell them. You can send them an email, contact them, let them know that in view of the travel ban, you respectfully want to request a return of your passport pending whenever they are ready. So that way you don't lose your opportunity in another place. I mean, what's the point of keeping your passport for 10 months and now travel ban is there? So because there is no consular officer that will defy this travel ban, that I can assure you. So even if the officer desire to give you, they cannot do it because of the travel ban. It simply means that the officer is ready to lose his job or her job. So just send them an email, request that they return your passport pending whenever they will start processing again. So just say, in view of the travel ban, you are requesting that your passport be returned to you at this time. And once they resume processing, they should let you know and you will send in your passport again. That's what I will do. Next question, please. Good afternoon, sir. Well done for all you are doing. Thank you. May God bless you. Amen. Is proclamation affect EADOPT application for Nigerian? Yes, it affects every benefit. The proclamation use the word benefit or the not the well, based on the proclamation, they came up with a policy. Yeah, the policy used the word benefit, so it affects every benefit. Next question. Hello, sir. I got my green card through marriage since 2019. I filed for naturalization since July 11, 2025. Till date, I have not gotten any update yet. Is there anything I should do again? Well, I don't know if this person is from the travel ban country, but if you are from the travel ban countries, there's really nothing you can do right now except to wait. But if you are not from the travel ban countries, what you should do is to first check the processing time. If your application is still within processing time, then you hold on. If your application is outside processing time, submit a service request. If your application is outside processing time, you have submitted service request and nothing is happening, then you do what is called congressional intervention. But if you are if you are from the travel ban countries, all you can do for now is wait. There's really not much anybody can do. As I said at the beginning of this podcast when we were giving the update, even the USCIS officers themselves, they don't have anything doing right now. Many of them, because all the interviews they were supposed to be doing, they have been instructed to cancel it. All the review they are supposed to be doing, they have instructed them to place a hold on it. So many of them don't have anything doing right now, and that is why they are diverting them to the issuance of notice to appear. So for that reason, there's really nothing anybody that can do if you are from travel ban country other than to wait. Next question, please.
1 second, I'm looking for it here. Okay, this is it.
Good evening, sir. Please, sir, I have received an approval from NBC a week ago. All I'm waiting for is an interview date. Is there any hope? Well, right now, everything is on hold, including interview scheduling. Everything is on hold. Let me see. Do we have any upcoming interview at any embassy from any travel ban country this January?
Well, we have some clients that just went there after the travel ban took place.
And what was the outcome?
So they were told that because of the travel ban, they would not be able to approve them. That as soon as they know that there has been a review or it's been revised or lifted, that they should now send an email to the embassy though so they can be rescheduled.
Okay. Well, what we have noticed in our office, since the travel ban took effect, our clients who have attended interview, they have been told that the interview was conducted, but they told them that because of the travel ban, they will not be able to approve them right now, that they should hold on and wait and see and follow the news and update. That once the travel ban is lifted, they should send an email to the embassy to request that their case be reopened and revisited. So that is all that happened. So those are clients that we have who attended interview after the travel ban started. Clients from travel ban countries. So that is the update that we have. As I said before, no consular officer will approve anything in contravention of the travel ban. That simply means that they are tired of working. They will be sacked. Okay, next question. Good afternoon, doctor. Can you please explain further the non-minister category will be expiring by January 29? Okay, that is talking about the religious workers. There are two categories of religious workers. We have religious workers who are considered ministers. Ministers are people who are pastors, reverend father, bishops, canon, people who are ordained ministers. The second category are non-minister position. That is, people who do ancillary things for religious organization. For example, children's school, Sunday school teacher, children's teacher, church administrator, what other anything that is not specifically anything that does not require ordination, any position.
IT?
No. IT is not a religious worker. I said children's teacher, Sunday school teacher, administrator, church administrator. All those clerical job or supporting job that does not require the beneficiary to be ordained, to be an ordained minister. So those are the two categories of religious workers. So the one that is ending, the one that is sunsetting is the non-minister category. That is, those who apply not as an ordained minister, but in a non-minister capacity. Those are the ones that is expiring on January 29, 2026 at 11:59 p.m. 11:59 p.m. on January 29, 2026, except the Congress extend it. We are hoping that the Congress will, but who knows, under this administration, especially with the way our president is really anti-immigration right now, we really don't know. We don't know, but we are hoping that they will extend it. But I will update you if it is ever extended before or on that date. I will let you know. But unless it is extended, anyone who is on R1 and is not an ordained minister, that will be the last day they will be able to do that. Anyone who has a pending I-360 and is not an ordained minister, they will not be able to apply for green card. Anyone who already has a green card application pending and is not an ordained minister, the green card may not be approved. So that is the implication, unless it is extended. So I hope that explanation is very clear. So next question. Hello, sir. Please, how soon are EAD applied as part of adjustment of status application approved in recent times? Well, it depends on the location. I think you have to check the... please help me check the processing time. Huh?
It's all under scopes now, so I can check.
Yeah.
If it's under scopes, I checked the other time and it said 5 to 5.5 months.
Okay.
But I mean,
Well, with the travel ban, I'm not even sure if they will approve application for employment authorization right now. But we will be observing. Remember, this is something that they just started this January. So we will be observing and we will be updating you. If we receive any approval, we will let you know. But for right now, did you check the processing time?
That's what I'm checking right now.
Okay, go to the next question. I will announce the processing time once I have that information. Okay, well done, sir. God bless you and your team. Amen. Thank you. Please, can someone already in the US still apply for EB1 with all these things going on, and what is the probability of approving it? Well, everything going on right now does not have any impact on whether it will be approved or not, because EB1 has its requirements. So the question is, do you meet the requirement? Okay, before I go further, the processing time for employment authorization based on pending adjustment is 8.5 months, 8.5 months. So as I was saying on the EB1, the requirement is what matters. The travel ban does not affect the requirement. The only area where the travel ban may affect it is that the review that they are doing right now, they may come up with more stringent, but I don't even think so, because the requirements are statutory. For the requirement to change, the Congress will have to change the law. So right now, the requirements, they are as contained in the law passed by the Congress. They are codified in the Immigration and Nationality Act. So I don't think there is any likelihood of the requirement changing, except the Congress changed the law. So can you apply right now? Yes, if you meet the requirement. For your information, EB1 requirement is entirely different from EB2. For EB1, you have to establish that you are one of the top 10% of your profession. You have attained the pinnacle of your career for you to be eligible for EB1. I always tell people that anyone who is in school, no matter how smart you are, even if you are a genius, if you are still a student, you are not eligible for EB1. That is the law. Because you can't be a student and then claim that you are on top of your profession. Certainly, some people are still teaching you, so there is no the requirement and schooling, they are not consistent. A student can get EB2 approved, but EB1, it is unlikely. So if you meet the requirement, can you apply? Yes. Even if they don't approve it right away, at least you'll be on the queue. And then the good thing, if you meet the requirement, because EB1 is current, visa is current, you can actually apply concurrently, meaning that you can file the I-140 and the I-485 together. And if you do that, one of the major benefits is that no matter how long the pause is, it keeps you in legal status. The only problem is, if at the end of the day, if it is denied, then you will be struggling to keep yourself in status to do something. But for as long as the application is pending, it keeps you in status. Next question. God bless you, sir, for your great job. Thank you. Please, I'm await an interview date from NVC for my R1 visa, and I still have an interview on a B2 visa. Can still go for the interview, sir. Well, I don't know if this person is from the travel ban countries. He didn't say. But of course, if you are from the travel ban countries, even if you attend the interview, they cannot issue any visa right now. If you didn't get a notice of cancellation from the embassy, I will show up on the day of the interview. You probably will be told the same thing that we have been telling you here, that some of our clients who have interview have been told by the embassies. They will tell you that they are not able to approve you at this time, but you should keep an eye on the news. So once the travel ban is lifted, you send them an email and they reopen your case and conduct a new interview and then approve you if you are eligible. So next question. But if you are not from the travel ban country, I need to finish that before I go into the next question. So if you are not from the travel ban country, so all these things may not affect you. So it's a different ball game. So since you didn't indicate, I assume that you are probably from one of the travel ban countries. So next question. Good afternoon, sir. Please, is there anything that says premium or expedited for spouse filing? Because I had something like that, paying $1,700 for spouse expedite. Thank you. No, I'm not aware of that. Even though the question is not very clear, because if you are talking about spouse filing, are you talking about adjustment of status? If you are talking about applying for green card, there is no premium processing is not applicable for any category of green card. Even if it is employment based, even if it is EB1, even if it is investor, even if you marry a US citizen, anything that has to do with adjustment of status, premium processing is not available. It has never been. Not that it was cancelled. No, it has never been. So if that is your question, premium processing is not available for you. So there is no 1,700 that can make that happen. Premium processing is only for non-immigrant visas. Next question. I'm a marriage-based green card. Filed a green card for son who is here since April 2025, yet to get receipt from USCIS. Do I send in another application with another payment or not? No.
She sent the follow-up.
Okay, let's see the follow-up. Okay, green card filed April 2025 for 20 years son who is here. Did not receive a receipt yet from USCIS. Do I send another application with new payment or wait? I try calling but no one comes to the phone. Yeah, USCIS is not very good at answering the phone. Well, immigration, this administration has made it extremely difficult for us to predict how things work with immigration. I can tell you that in our office here, there are applications that we filed since April of last year, and we just received the receipt notice this January 2026. You can imagine, since April of last year. So it is possible that your application falls into the general delay because of all these pause, hold here and there. It's affecting a lot of things. However, there is something that I want to point out from your question, even though you didn't ask me that question, but I see a little problem that I want to address. Your question says that you are a green card holder, and you also indicated that you filed a green card application for your son who is 20 years old. The problem that I see here, it may not be a problem, but I just want to point it out to you. You didn't indicate whether your son has been maintaining legal status, because if your son has been out of status, that application is going to be denied. That is one of the major differences between a green card holder and a U.S. citizen. A green card holder cannot petition for anyone who is out of status. So it is only a U.S. citizen who can petition for someone who has been out of status. So if your son has been out of status, because you are a green card holder, that application is going to be denied. That is the law. It's not even about this administration. But if your son is maintaining legal status, then I will go ahead. If it is imminent that your son is going to turn 21, because the priority date really matters, I will continue to call USCIS until I'm able to get somebody on the phone, because you can't even do a service request because you don't have a receipt notice yet. You cannot do it until you have a receipt notice. So what I will suggest, call USCIS number, select any kind of options, even if you don't qualify for that option. Select whatever option until you get somebody, a physical person, to talk to you on the phone and express your problem to them, that look, your son is going to turn 21 and that will be problematic, and you have not received receipt notice. You need to find out what is going on. But if your son is out of status, I will not even bother to follow up, because that application may end up being denied. And of course, you know what that means. Your son is probably going to be placed in removal proceedings under this current administration. Yeah, next question, please. I'm planning to go to Nigeria and I have a green card. I hope I will not have any challenges coming back at the point of entry. I plan to spend 30 days. For as long as you don't have criminal record, I don't think you have any cause for concern. No criminal record, no issue. And if you got your green card through marriage, make sure that you put your house in order before you step out. Next question. Good afternoon, doctor and team.
No, this one's fine. It moved.
Okay. Next question. I have my permanent residency and I haven't used it to travel yet. I'm about to travel to Europe. Is it advisable to travel out for now? Yeah, it's the same one as the one I answered before. For as long as you don't have any criminal record, you can travel. And of course, if you obtain your permanent residency through your spouse, you also have to make sure that your marriage is in order and you put your house in order. You don't have issues with your marriage. Next question. Good afternoon, doctor and team. Please, can a person still awaiting response from USCIS travel within the US A with Nigerian passport. Yes, if you have unexpired passport, yes, you can use it to travel. If you also have a real ID compliant driver license or ID, you can use it to travel. Next question.
Provided that there's no criminal record, I guess.
What did you say?
If they have criminal record, it's advisable not to, or it doesn't
No,
matter,
they are talking about domestic travel.
and they don't check those things. I'm asking.
No. See, what do you TSA officers only check identity.
Okay, no.
Yeah.
Sorry.
Well done, sir. Will filing for citizenship affect a case from Medicaid fraud division on not completing home aid hours, so exclusion and suspension of license, but not charged with fraud? Well, this is a very good and technical question. Good in that it gives me an opportunity to explain something about citizenship application. If you look at citizenship application, well, let me be sure I'm not mixing this up with removal proceedings. Can you quickly help me check N400? Is there a question that says that have you ever committed an offense for which you are not charged?
I believe so.
I think there is a question like that. I just want to be sure, just confirm. Yeah, that is where this question is going to be extremely delicate. When it comes to citizenship can be denied for somebody who has not been convicted of any crime because of the requirement of good moral character. There is a requirement for citizenship, which means that the officer will have to determine whether this person is a person of good moral character. So, because you have not been charged or convicted of any crime, so the question that says, have you ever been convicted? Your answer will be no. Have you ever been arrested? Your answer will be no. Have you ever been charged with a crime? Your answer will be no. Then this is where it becomes tricky. Have you ever committed an offense for which you are not arrested?
Yeah, it's asked.
What's the number?
Convicted or
It's page 8, number 15A.
So the question is, if you look at form N400, page 8, question 15A. Let me see the question.
There's this whole bit before, but the actual question is right there.
Yeah, I remember there was such a question. I just want to, okay. Yes. Have you ever, page 8, question 15A, have you ever committed, agreed to commit, asked someone else to commit, helped someone commit, or tried to commit a crime or offense for which you are not arrested? So that becomes a problem. So how are you going to answer that? So that is the only concern I have with this question. If I'm in your shoes, I will pause and see the direction that all of these things are going, especially if you are from the travel ban countries. So I will pause and wait and see the direction that this Trump administration is going with all these pause. Because, like I said, after the pause, they will come up with new rules and regulations. I remember there was similar pause in 2008 during the religious visa crisis. A lot of fraud were uncovered at the time, and they put a hold on it at that time. So when they resumed, the Congress passed a new law mandating a site inspection. So that was when they introduced site inspection. That was when they introduced any religious organization filing a petition to submit the pictures of the church from inside, from outside, showing the signboard and all of that. Was when they came up with all those things. So I'm envisaging a similar situation. So once this pause is over, they are probably going to come up with new rules. So I will probably pause and wait and see what new rules they will come up with and see if it is safe to do so. But for now, I will just pause. That's me. But the challenge you are going to face is that question. Because once you answer yes, then they are going to start asking what happened. And then you are going to explain to them what happened. And then the officer is going to conclude that you don't have good moral character. And you won't be able to defend it at that time. Next question. Now that they have paused benefit for Nigerians, so are applicants for adjustment of status now out of status while the pause is in effect? What do those people say when encountered by ICE? No, you are not out of status. You still have a pending application. Just make sure you carry your Form I-485 receipt notice along with you. If you are encountered by ICE, tell them that you have a pending application for adjustment of status. So you are not out of status at all. That is still a valid excuse you can give until the application is adjudicated, either approved or denied. Next question. I'm on H-1B with an approved EB2 NIW and waiting for my date to be current mid-year. Does the pause ban on Nigerian green card processing affect the adjustment of status for EB1, EB2, NIW? Yes, it affects everything. However, it doesn't stop you from applying. As soon as your visa becomes current, go ahead and submit your application. The only thing they cannot do is to adjudicate it for now. And even based on what you wrote here, your priority date is still going to be current probably by the middle of June. In this case, USCIS has only been given 90 days, which is 3 months. So February, March, April. So by April, we should know which way we are going. They have only been given 90 days to come up with a new rule or new policy or come up with how they want to fix all these issues. So before then, we will have known where we are going. But if for any reason by then we still don't have an idea of where we are going, since they are still accepting application, you just go ahead and submit your application for adjustment of status so as to keep yourself in status. Next question, please. Sir, I'm on M1 visa. I have 3 months visa, which will end by February. What is your advice for me to stay on status? Well, this is a blanket question. He's open-ended. What I will just tell you, since you are still in status, go and consult with an experienced immigration attorney and check your options. Look at what options. If you don't plan to return back at the end of your period, you need to apply for a change of status. You need to do something to keep yourself in status or an extension of your status. Remember, M1 is a non-academic student. So it is also part of the one that is affected by if you are from the travel ban country. So there is really not much you can do. But if you determine what your plan is going to be, if you are going to apply for an extension of your status or a change of status, you get it ready and you submit the application before the expiration of your status so as to keep yourself in status until they come up with new policy or whatever they decide to do. But if you also want to have an idea, I will tell you to go back to some of our old podcasts. We have some topics where we discuss how to change status, how to extend status. We discussed every category, H1B, R1, I-140, EB1, EB2, NIW, EB3, EB4, EB5. We have podcasts on all of these things. So that will give you an idea. But to tell you what your options are, that is not something that we can do on this podcast because that will take the entire 1 hour. Next question. Hello, sir. Thank you for your service. I believe that my husband has defrauded me for immigration benefit. What should I do? Well, I would need more information about this. I mean, If your husband defrauded you for immigration, so I'm assuming that this person is probably a US citizen and you believe that your husband used you to get papers or something. I mean, this is not the kind of question for a podcast. If you want one-on-one consultation, I will tell you, call our office. I can ask you more questions and all of that. Because let me say something. It is not in my DNA to destroy people. That is not who I am. I try as much as possible to help people, to fix things, not to destroy. It's very, very easy to destroy, extremely easy. But to fix something is extremely difficult. And I can tell you from experience over the years, I've seen people who are married legitimately, they even have children together. And because of a misunderstanding, the one who is a US citizen reported the other to immigration that the marriage was fraud. And the innocent person was placed in removal proceedings. I've seen a lot of things. I've seen couple who have children, who are even Nigerians. Both husband and wife are Nigerian. One of them is a US citizen, one is not. Legitimate relationship. They have a child together. And one wrote a letter because of misunderstanding. One wrote a letter to immigration claiming that they use him for green card. And they placed the husband in removal proceedings. I've seen all kinds of things, what people do out of anger, what people do at the moment of displeasure, at the moment that they are angry. So it is something that I'm extremely reluctant to do. I usually don't help people to destroy other people. That's not my calling. It's not something that I do. That's just the simple truth. I will advise you, no matter what happens, take your time, sleep over it, determine if you really want to go this route. Then if you are convinced, because there are also some evil people. I mean, like I said, I'm 60 years old. I've seen all kinds of experience. There are some evil people too that you begin to wonder what exactly is going on. We have seen all kinds of things in this life. I have consulted in the past for clients who are even Nigerian. Two of them, Nigerian. One is a US citizen, the other is not a citizen. They have been married, they have 3 children. They both came to my office to consult with me. After I told them what we are going to do and how we are going to do it, the one who is a US citizen made payment for us to start the work. And we started working on it. The following week, the one who is a US citizen, I don't know for whatever their problem is, came to me and talked to me privately, telling me not to file the application, that he actually wanted the spouse to be deported. Meanwhile, when they came to me, 2 of them were present. In the presence of the 2 of them, the one who is a citizen made the payment. Now he came back later. He told me that, he's not asking for refund. He just didn't want me to file anything because he wanted his spouse to be deported. I asked him, why? Why do you want to? He said that is the way that he wanted his spouse to be deported. So at the end of the day, while I was thinking about how to resolve it, the other one kept on calling to find out what is the status. Has my application been filed? What is going on? I couldn't tell him because of attorney-client privilege. I couldn't tell him that your spouse told me not to file. So at the end of the day, I invited both of them and I told them that, you know what, I don't want to handle this case anymore. For personal reasons, I want to withdraw from the case because I'm not able to tell the spouse. If I tell the spouse, that will be a breach of confidentiality and I will be in problem. So I couldn't tell the spouse that this is what your spouse told me. So the poor woman believed that we were working on our case. Meanwhile, the spouse told us not to do anything. So we've seen all kinds of experience about this life. So again, I'm not going to tell you whether you should destroy this guy's life or you should not. That will be your call. But I will tell you, sleep over it and really think about it. Sometimes when we allow God to fight our battle, we get better results than when we try to do it for ourselves. That would be my opinion.
It's 1:55. How many more questions?
Oh, well, it's all we've been on this now for almost 2 hours, so we have to stop. So where are we? At least I can't go beyond 2 p.m. I also have another.
Okay, so I'll remind you too.
So how many more questions?
Oh, there's so many.
Oh, well, as you already know, we started this program almost 2 hours ago at 12 o'clock. So on the dot of 2 o'clock, we are going to stop. Whichever is going to be the last question, we are going to stop. That will be 2 full hours. I decided to do 2 hours today because, as you can see, the way I'm dressed, I'm not in court today. So that's the only reason we have all this time. So, next question. I'm a Nigerian. Can I travel with parole, sir? Thank you. I think I've addressed that question before. Like I said, it doesn't affect that. I think I've answered extensively. My suggestion is that if I'm in your shoe right now, I will not travel. Not because I have anything that says if you travel, you'll be in trouble, but because of the inconsistency of this government policy. They are so inconsistent. So I would rather have my green card before I travel at this time. Things may change tomorrow, but the way they have been inconsistent. Last December, when they put Nigeria on the travel ban, they specifically indicated that it does not affect people who are here. Then came January 1st. They now said even people who are here too, they are now going to. So there have been a lot of inconsistency. So for that reason, I will naturally, with travel document, because you are not going to the embassy, it should not affect you. Should you be able to travel? Yes, that is the natural thing. But the reason I'm exercising restraint right now is because of the inconsistency of this administration. They are so inconsistent. And now that they have started reviewing all the cases that were previously approved, what if you are outside and then they review your case and deny it when you are outside? So those are some of the risks about traveling. But can you travel? Yes. Is it advisable? I will not do it. Next question, please. God bless you for your good work, sir. Amen. What can you advise someone who has a pending case with valid work authorization to do when encountered ICE raid? Silent or show them your work authorization? Well, work authorization by itself is not a status. It's just something that allows you to work, because there are people who may have work authorization and their pending relief may have been denied. So what you need to show them is the receipt notice of what you have pending that gave you work authorization. If you have an application for green card, make sure that in addition to your work authorization, you have the receipt notice of the I-485. If you have an asylum pending, make sure that in addition to the work authorization, you have the receipt notice of the I-589 pending. So those are the things that you should show ICE if they ask for anything. But if they don't ask you, just maintain your cool. Next question, please. Please, can a green card holder from a banned country like Nigeria apply for citizenship now? Well done about and happy New Year to you and your crew. Thank you. Yes, you can apply. They will not adjudicate it, but since they have 90 days to come up with new policy, hopefully by the time they are ready to start reviewing and adjudicating application, your application will have been on the queue. But yes, you can apply now, and then you will wait in the queue. Good afternoon, sir. Just want to thank you and your team for giving your all to serving the masses. Thank you. I have no doubt that God will bless you, your family, and your team in Jesus' name. Amen. Thank you so much. We appreciate it. Thank you. Next question. Good afternoon, sir. Well done for all you are doing. Thank you. May God bless you. Amen. Is proclamation affect OPT application adjudication for Nigerians? Yes, it affects everything. All benefit applications are on hold. But if you are eligible, go ahead and apply, because OPT also has a specific time that you have to apply. You have to apply at the end of your graduation, and you have to apply before the program is over. So make sure you comply with all of that. So submit the application and then wait. But yes, it affects the application, but it will be in the queue. I think that should be we are a good place to stop for today. It's already 2 o'clock. I have other appointments, and besides, we have spent 2 hours today. No matter how much we try, we can never answer every question, because I know that lots and lots of people are on the queue. But I'm going to tell you, when you join next week, try to send in your question as quickly as possible. I hope and pray that God will keep us all safe to be able to continue to do this. As I always say, stay out of trouble. Lay low right now. This is not the time to be lousy. I know that my people, Nigerians, we are very, very loud, but this is not the time to be lousy. Don't participate in any online condemnation of the president, of the regime. Some of the things that I'm telling you, that I'm saying on this platform, I'm saying it because I'm a U.S. citizen. I can criticize the president. It is part of our right as a citizen. But if you are not yet a citizen, please don't participate. Don't criticize. Even physically, if you are in any place where they are condemning the president, where they are condemning the administration, please don't get involved if you are not a citizen. Online, on Facebook, on X, on whatever social platform, please don't participate, because this administration has zero tolerance for people they consider that they don't have interest of Americans. So until you get your citizenship, that's when you have all this right. Until then, I'm going to tell you, stay out of trouble. And please avoid criminal activities. Don't drink and drive, because when you get arrested, you make our job more difficult, because now the government is going to have tools to use against you. They are going to tell you that you are a flight risk. They are going to tell you you are a danger to the community. They are going to come up with all kinds of things to have justification for keeping you locked up. Please avoid all these things. I pray God will protect all of us. I hope to see you again next week. Until then, I remain yours sincerely, Dr. Olu Asekun, and my team members here.